Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic, LA making it impossible to evict the tenant for non-payment of rent. Hello, yes, another edition of Zoom Landlord Tenant Talk Radio coming at you every Saturday at 3 p.m. If you were listening live, the name of the song was Before He Cheats, performed by Carrie Underwood and released in August of 2006. The song was actually written by two Nashville songwriters by the name of Josh Keir and Chris Tompkins. They had originally wanted to give it to a recording star by the name of Gretchen Wilson, but she didn't want the song, so they tried it with Carrie Underwood. And she was a little hesitant at first about singing that song because she thought it was too destructive or created a bad girl image. She had just won American Idol, but she took a chance. And of course, the song raised to #1 on the charts and was a fabulous hit. Before we get into the opening topic, I wanted to give a quick shout out to Dr. Francine Nazarian. She is located in Tarzana. She is my wonderful foot doctor who is helping me with a bad foot sprain. And this Friday, she actually gave up her lunch to see me on an emergency appointment. So I want to put a thank out to her. Once again, her name is Francine Nazarian in Tarzana. Okay, let's start the show with the opening topic, and that is LA just made it impossible to evict a non-paying tenant. Under this legal system, tenants have no obligation to know their rights. Landlords are required to spoon-feed tenants their rights in order for a landlord to be able to enforce his contractual rights, such as get me the rent. The city of Los Angeles has no intention of creating a fair system for landlords and tenants. Their sole motivation is to protect tenants, a totally one-sided system. The city has passed a Tenant Anti-Harassment Ordinance, but no such ordinance exists for landlords who are certainly abused. The city has allowed tenants to obtain free legal representation to allow tenants basically to live free on the backs of landlords. Now, a very important part of the tenant protection statute for all residential units in the city of Los Angeles is that any violation by a landlord of the Los Angeles Housing Department ordinance is a defense to an unlawful detainer action. If you make any mistake, regardless, then you will lose your eviction case based on the way this statute is written. So I do want to show the first step, which is dealing with a registration certificate. Landlords, all residential units in the city of Los Angeles must obtain a registration certificate. I don't care that this is a single family home in Brentwood for $85,000 a month, or you have something in South Central LA. You must register your units. And in addition to registering your units, you have to give a copy of this registration to your tenants each year. Each year you have to register this unit. Now, for example, let's pretend you have a tenant who literally shot up the place with a gun in the courtyard. So of course, in addition to any criminal charges, you're going to want to serve this tenant with a 3-day notice to quit based on nuisance. Obviously, this is a nuisance. Well, if you haven't registered your unit based on the insane laws promulgated by the city of Los Angeles, then you will lose your case because you didn't register your unit and you didn't send a copy to the tenant. But it keeps getting worse. Let's move on. There are certain notices that you have to post on the property. And if you don't post these notices on the property, you are going to lose your case. So here's the first notice, City of Los Angeles Renters Protection Notice. Again, for every residential rental unit in the city of Los Angeles, this notice has to be posted. You don't post this notice, you lose your case. I don't care that the guy hasn't paid your rent in a month of Sundays. I don't care that he's terrorizing the apartment complex and having toga parties till 3 a.m. in the morning. It makes no difference. This notice is not posted, you lose your case. What else do you have to post in the city of Los Angeles? Well, you have to post the fact, the second notice, and by the way, all these notices are on my website at evict123.com. You have to post this notice on the property. That's a second notice that has to be posted on the property in a conspicuous spot. So usually that's maybe in the laundry room or by the mailboxes. But again, doesn't matter what the tenant did. If you don't have these notices posted, you lose your case. Now, is there something else? Well, yes. If your property is subject to the rent stabilization ordinance for the city of Los Angeles, this is a third notice that you have to have posted on the property. And if you don't have this notice, you're going to lose your case. I don't care what basis your case is on. These are the notices that have to be posted. Now, could there be more rules which would cause landlords to lose their case? Oh my God, I'm just getting started, everybody. So let's now talk about a new law that's only for RSO properties, and that deals, we did talk about this last week, but I think it bears repeating. This is that landlords under RSO properties, rent stabilization ordinance, those properties, you have to pay yearly interest on your security deposit. If you don't do that, and let's pretend the tenant owed you 4 months worth of rent, but the tenant's been there for 5 years, you took a security deposit of $1,000 when he moved in, but you didn't pay this yearly interest. If you don't pay this yearly interest, that means your 3-day notice to pay rent is overstated. And if it's overstated, that means you've lost your case. And tenants attorneys are doing this all the time. If you haven't done this, then right now, send a check. Again, this is only for properties subject to RSO. Send a check to your tenant, even good tenants, bad tenants, indifferent tenants, and give them, here's your interest on security deposit. Now, this form, this interest calculation is on my website at evict123.com. It's in the legal issues section. But I also have right there something called an interest calculator. So if you haven't done it for 5 years, it might be difficult for you to figure out how to compute the interest, especially since it has to be compounded since you didn't give the interest on a yearly basis. So use this calculator and then just send a check to the tenant. What we've been doing is when we take in a case for non-payment of rent, what we have been doing in these cases is if the tenant hasn't if the landlord hasn't sent the security, the interest on security deposit, what we will do is we will compute that and we'll take that off of the notice to pay rent or quit. We have a special 3-day notice which says, hey, you've been given a credit based on this figure of the amount of interest that you weren't paid. So that's one way we kind of get around it. But right now, if you haven't done this and you've got RSO properties, this is exactly what you need to do. Now, mind you, everything I'm talking about deals with just the city of Los Angeles, their particular requirements. This doesn't affect other places, though other places, other local jurisdictions have their own crazy rules. But this is just the city of Los Angeles. How are landlords supposed to know this? Where did they get this information? It is literally insane. But could there be more? Of course. So let's move on. And I'm going to move now to something called the fair market value. Now, this is an insidious one, which talks about the fact that if you have a 1-bedroom apartment that goes for $2,000 and the tenant didn't pay you the rent for the month of December, so you serve a 3-day notice, you file your lawsuit, you had all the notices posted, you've already lost your case because the city of Los Angeles, and I also might add, unincorporated areas of LA County, have what they call the fair market value, a threshold. So the threshold for a 1-bedroom is $2,081, which means you have to wait until January 3rd, next month, before the tenant will owe more than $2,081. Where are you going to know all this information? So these are the requirements that the city of Los Angeles has, unlike any other place. But let's move on. How about a 3-day notice? Well, in a 3-day notice, and this is the one I have on my website in the free form section, in a 3-day notice, you have to put the standard things that the state of California requires, but you also have to do one more thing. On the bottom of the notice, as you can see here, you have to put how many bedrooms so that the tenant can compute whether you're above the fair market value or not. How many bedrooms? If you don't have the bedroom count in your notice, you lose. Now, in addition to the city of Los Angeles, unincorporated areas of LA County not only make you put in the amount of bedrooms, but they also make you write what the fair market value is. That's another trick by the city of Los Angeles. So what we have, of course, is a system that is designed for landlords to lose their case. There's no other jurisdiction that creates all these insane laws so that landlords will lose their case. But let's move on to one more thing. And I promise you, this is going to be the last thing. After you serve your 3-day notice, guess what you got to do? You have to upload that notice to the city of Los Angeles. And this is what they call their eviction filing system. You have to create an account and you have to upload that to the city of Los Angeles. And God forbid you don't have much technological ability. What are you going to do then? But again, if you don't upload that notice to the city of Los Angeles within 3 days of the service of the 3-day notice or any notice, a 30-day notice, a notice to perform or quit, you are going to lose your case. So you can see that this is a system designed by the City Council of Los Angeles and the Mayor of Los Angeles to create havoc for landlords. It has nothing to do with what's fair and what is reasonable for landlords to know. And again, we have a system where the tenants have to be informed by the landlords of their rights. The landlords aren't informed by the city. Nobody comes to us and posts notices on our place as to, hey, you better do this. They just fine you, either in terms of your registration fees, or the ultimate fine is that you will lose your eviction case. And that, my friends, concludes our opening topic of LA just made it impossible to evict non-paying rent tenants. What we're going to do now is we're going to open it up to questions and answers. For those people that are in the Zoom room, I will be happy to call on you. If you electronically raise your hand, you'll see that in the bottom of the tool. Remember, at the toolbar, remember that this telecast is for informational purposes only. It is not a substitute for legal advice. Again, if you want to talk to me, please electronically raise your hand, and I'll be happy to call on you. Again, this telecast is for general information only. If you have a specific case with my office, please call me on Monday, and I'll be happy to talk to you. And if you are talking to me, please leave your camera on because it makes it much more enjoyable for all the other listeners and, of course, for myself as well. And you guys who are watching on YouTube, do me a favor. If you like what you're hearing, you want to learn about landlord-tenant law in California, or you want to learn about property management, then hit that like button and subscribe to my channel. If you do want to know how to get into the Zoom meeting rooms every Saturday at 3 p.m., just head on over to my website, which is evict123.com. You'll get the credentials for joining in. If you want to just leave a comment in YouTube, I'll be happy to answer that because I get to almost every comment that you guys leave. And with that, we're going to open it up to our first caller, whose name is Tony. I'm going to ask you to unmute yourself.
Hey Dennis, how you doing?
I'm good on a Saturday.
Good. Dennis, quick question. Is it better to do a 3-day survey, 3-day notice, or a 60-day substantial remodel? Or would you be able to do both at the same time?
Okay, when you say a 3-day notice, are you referring to the fact that the tenant didn't pay you rent?
Oh no, not pay rent, but I guess the tenant they have a whole bunch of work material and stuff like that on in commons area.
Okay, so
And
I would go on that. If you're going to go, first of all, very few jurisdictions allow you to do a renovation eviction.
Mhm.
What jurisdiction is your property?
I'm sorry, City of El Monte.
What is it? One more time?
City of El Monte.
Oh, El
El Monte.
Monte. In
Right.
El Monte, you are allowed to do a renovation evictions, but if he's in violation of his contract by having personal property stored in the common areas, I'd just go that route.
Okay.
So serve a 3-day notice for him to remove it at the end of the third day. If the items are still there, then you have the right to evict.
And I
Anyway,
think that's my
go ahead.
concern. Yeah, I think that's my concern. I mean, if he does remove everything, would I
Well,
then be
then,
able to serve the
then,
60 day?
yeah, then you can go forward with the renovation eviction. But if you're going to do a renovation eviction, it requires a 60-day notice. You also first have to get the quote scope of the work that you're intending to do. It's usually written out by a contractor, which will show that the work does require building permits, that the work will render the premises uninhabitable for at least 30 days. And you also have to first pull those permits. So once you have the permits and the scope of the work, then we can first serve a 60-day notice. And of course, we do have to give relocation, which is 1 month's rent. But that's why I recommend serve the notice to perform or quit first. And then if they don't, then we can bring forth an eviction. However, since your property is located in El Monte, we
Mhm.
have another trick is that we have to, as your property is subject to statewide rent control. So after we serve the notice to
Correct.
perform or quit, statewide rent control requires that we serve a 3-day notice to quit. I know it doesn't make any logical sense, but that's what the law, that's what the law is. Anyway, thank you very much, Tony. We're moving on to Suzette. How are you? Ask you to unmute yourself, Suzette.
Okay, here I am.
Yes, you
I don't know if
are.
you can see me. Anyway, my question, hi Dennis.
Hello.
My question today is if your property is in trust, can a tenant go after you if,
Oh,
they're trying to
absolutely.
sue you?
Trust doesn't shield you from liability. They're basically suing you, and you're
Okay.
the trustee of the trust. So basically, it's your trust. So yes, it doesn't shield you. If you want to be shielded from liability, you want to instigate a limited liability company. My firm actually does that. When the attorney there, it's very coincidental. The attorney who does it there at my office, that attorney's name is Madison Block. Oh, hmm. Oh, that's right. It's my daughter. So she
Any
does those
relation?
there. Yes. Yes.
Okay.
No, known her for 32
And then
years.
one other question. If my property was I got a citation and then I'm in the middle of fixing these things, the tenant still has to pay the rent, correct?
Well, the issue is that if the tenant told you to fix something and you callously refuse, and then they had to go to the health department, I wouldn't ask for rent until such time as you have taken care of those items, because that would be a defense in an unlawful detainer action.
What about if they never asked to fix?
If they never asked to fix, then I would immediately do the work and then serve them with a 3-day notice.
Sounds good. Thank you.
And thank you. Good questions. We're moving on to, says here, Milhawa Yi, a realtor.
Hello.
Hi there.
Hi. Yes, I have a question. We served 60-day notice for correcting a city violation for illegal room, but the tenant did not move out. So we filed a UD 100. My first question is, can she file an answer before being served?
Anybody can file an answer before being served.
Okay.
If there's a lawsuit filed, then I can file an answer. But I didn't
Uh,
really understand what the issue is. Did they create an illegal room?
No, it's a
You created the illegal room.
landlord's fault. Yes,
Okay, so you've got an order to comply to discontinue the use.
that's correct.
Okay, so you
Yes.
needed to serve a 60-day notice. You also needed to pay relocation, which is 1 month
Yes.
rent.
Yes. Yes.
Okay, and the tenant hasn't moved, so now
Oh.
they're contesting the case?
So
Yeah.
she filed an answer, but
Mhm.
her defenses are harassment, retaliation, and inhabitability. So
Well, it
also
is
she
uninhabitable. I agree with her because it's an illegal unit. So, and it's not retaliation because you're being ordered by the municipality to do the eviction. So I don't see any problem with that at
and
all. Oh, sorry about that. We're moving on to John, 2021. How are you?
Hi, Dennis. Thank you for taking my call. I am confused a little bit, and maybe that's the way they want it, as you were saying in your earlier talk. The RSO property in the city of LA, they've changed the formula, as you're well aware, and I think it was codified a week ago Friday or something. I don't know when it's going to be signed, if it has been, and when it takes effect. But my question is this: our rental registration form gives the amount we are able to charge an increase from July 1st through June 30th. So if I have a tenant who's due for a rent increase in the first half of 2026, will it be that 3% allowed, or will it be the new formula? Like when, I don't even know what I can raise it.
Good question. Well, first of all, to make it a little bit more explanatory to the people who are listening, the City Council of Los Angeles had a rule that rent increases were anywhere from 4 to 8% based on the CPI. That's how it's been since 1978. So they just recently changed it and they said now it's going to be rent increases anywhere from 1 to 4% only, 1 to 4% only, and it's based on 90% of the CPI. Currently, the CPI, Consumer Price Index, for the city of Los Angeles is 3%. So 90% of 3% would be a 2.7% rent increase. Now, the issue is when does that take effect? And the answer precisely is God only knows. It has been codified. We wait for the mayor to sign it, but I've read online that it's really not going to take effect until July 1st of 2026. So right now, do your rent increase as soon as you can, legally do so. And if I hear anything else, I'll let you know. And thank you very much, John. Appreciate that. We're moving on to somebody from old land of Greece, Aristotle. How are you?
Hi, Dennis. Great show. I'm calling
Thank
you
you.
from New York, and I have a four-family home, four-unit home, and it's a free market. Everything is free market with month-to-month leases. I recently transferred the property from my personal name to a LLC. Oh, about 2 years ago, I did that. Do I have to, I notified everybody, they're all paying me in the name of the LLC. Do I have to send out new leases with me renting as the LLC to each tenant? Or can I just send out a letter and done?
Okay, first of all, are there four houses on one lot? Is that what I'm hearing?
No, no, no. It's a four-family house, a four-unit.
Oh, it's a four-unit building. Okay.
Mhm.
So first of all, with regard to the change of ownership, which there was, there's a specific form that you need to use in order to legally change it. So if you just did your own letter, I'm telling you, it's not going to have the proper wording in it. I do have that form on my website, evict123.com. Go to the free form section. Take a look at my form. If you didn't have every little element in that form that I have, then it's no big deal. Just send a new one out today. Now, what city is this property located in?
Queens, New York, New York City.
Oh, your property is located in New York?
Yes, yes. I'm in New York and I'm calling you from New York.
Okay. Then let me take back
You're
everything I
national,
said.
buddy. You're national.
Yeah, I might be national, but my expertise is only for California. So I really am not prepared to discuss anything dealing with New York law. However, I can tell you, very proud to tell you, that I will be in New York. I think it's around February 2nd for the Laker New York Knicks games, and I hope your team loses. But Aristotle, I'm sorry, I don't give any advice out for a jurisdiction that I'm not located in. But thank you very much. Moving on to Deborah D. That was the first time that ever happened. Deborah.
Hi. I'm
Hello.
about this new requirement for single family homes that are rental property that need to be registered called Just Cause. Do you know about that?
I certainly do. Is your property located in the city of Los Angeles?
Yes, it is.
Every residential unit, including a single-family home, needs to be registered with the Los Angeles Housing Department. I showed you that registration certificate, and it
Right,
needs
right.
to, your case, since it's a single-family home with only one house on the lot, it needs to be registered under the Just Cause Ordinance. Technically, you would lose an eviction case if you didn't register that unit and send a copy of that registration certificate to your tenant.
Okay, well, that's okay. Well, I did that part. My question is, does it have to follow the same raising the rent requirements, this 2.7, or can I still do whatever I want with the rent on a house?
And the answer is that this, under the Just Cause Ordinance, the city of Los Angeles doesn't make any rules in terms of rent increases. Since your property is a single-family residence, under California law, you're allowed to increase the rent to market value anytime you want.
Excellent. Thank you.
And thank you. Good questions. Moving on to, who could this be? I don't know, but I know his name is Harold. Say hello, Harold.
Hello. All
Hello.
right, here we go, Dennis.
You got
This
your
not-
camera up in the wrong spot, darling. I can't
Oh,
see
wait
your
a second.
face.
Can you see me now? Hold on, let me do this. There we go.
There we go.
I was eating. Yeah. Okay, so does this apply to we were talking about lodger. Does the landlord have to register if he has a lodger?
No, it's totally exempt from the Just Cause Ordinance. In fact, we just did another one on Friday where we served just a straight 30-day notice to vacate with no reason on a single-family home in the city of Los Angeles where the owner lives in the same home as the tenant, and they both share kitchen privileges and living room privileges. So there is no basis of registering.
So I don't need to give them any lawyer forms or there's no habitability.
No, whenever you're unhappy with this guy, serve him with a 30-day notice, then that form's on my website.
I'll be hitting you up, Dennis. I don't want to screw up. That's why we call Dennis. Okay.
Thank you so much, sir. Moving on to another regular, Margaret O'Brien. What you got for me today?
Regarding the rent registration, we have to post it every year, the new one.
No, the registration you just mail to the tenant. You don't have to post it. That's the registration certificate that you get every year. You mail it to all of your tenants.
When I get it, we get it in February, right?
I'm not sure when you get it, but whenever you get it, send it to your tenant.
Okay. And then the other question I have, why can't we ever find out how many RSO properties are way below market? I mean, I have a single for $750 and I would have to wait until it comes to 1,800. That's 3 months.
Oh, you're talking about the fair market value.
Yes,
That if
excuse
it's a
me. Yes.
single, then the let's see, for a single,
1,800 or something.
it's $1,856. Yeah, this is just a boondoggle by the city of Los Angeles, which says that if the tenant doesn't pay you rent in December and your rent is $750, you can't do anything. In January, now it's up to $1,500, you can't do anything. And then finally, when you get to $2,250, 3 months, the city of Los Angeles is just stealing your money. They're making you wait 3 months before you can go forward with an unlawful detainer. And this is just criminal.
What can we do about it?
Sell your property and move to a civilized state. That would be my guess.
Okay, thank you.
And now we're moving on to Albert. How are you today?
Great, Dennis. Thank you for the great show. Quick question. When you mentioned about lodge giving 30-day notice to a lodger, That does not apply to ADU, right? If there's an ADU in City of Los Angeles.
No, a
Okay.
lodger is where it's a single family home and the owner of that home lives with another person. They rent out a room. The tenant has full use of the house. He can go into the kitchen, and that's considered a lodger. So it's under Civil Code Section 1950.5, just to impress everybody out there. And all you need to do is serve a 30-day notice regardless of how long he's been there. And there's really no defenses because under the law, it's not considered discrimination, even if you're evicting him because of one ethnic persuasion, because the law states that you're allowed to choose who lives with you. If you only want, somebody who's of Asian descent, because you're Asian, then that you have the right to do so.
Yes. Other question: if the tenant is in an RSO unit, which I want to pay, let's say the interest for the last few years, that particular tenant who was on the lease has moved. What should I do now? I mean, who should I make the check to?
Well, when he left, did two people rent the premises at the same time?
When I took over the building, there was this lady and there was this other guy, but the other guy was not on the lease. Only the lady was on the lease, and she's gone
Okay,
for
so since
a few
she's
years.
gone, then really you should have accounted. Well, I don't think the person who's there, who wasn't even on the lease, is entitled to any interest on security deposit. So I think you're free and clear on that.
Thank you. I appreciate it. Thank you.
Okay. Alan Zaman, I'm going to ask you to unmute yourself.
Hi there, Dennis. I just had a very general question to ask you. In your opinion, as a landlord-tenant attorney, where do you think the future is headed for landlords who are looking to invest in LA, but like every day as we see new laws are being passed left and right, just making it so much harder?
Well, they're just making it so that the rents will go up because nobody in their right minds wants to do any building projects in the city of Los Angeles unless you're given such tremendous tax credits to do so, which is the only way they can encourage investors to do so because the laws are just insane, making it very difficult for landlords to enforce their contractual rights. So I've said this before that while I do have a lot of property in LA County and some even in Ventura County, I will not invest in the state of California anymore.
Got it. Thank you.
That's my opinion.
Yeah. Thank you for your input.
And thank you. Moving on to, says here, Devo Award. I'm going to ask you to unmute yourself.
Hi, it's Divya, and happy holidays, Dennis.
Thank you.
I have two questions. One question is in relation to what you spoke about yesterday on the Apartment Owners Association meeting about like calling references. I follow very closely. I follow you for years. Anyway, the question is when you're calling previous landlords, like for references, like how do you know and how do you get around like not calling Uncle Sam or, the friend? How do you really know that that person you're talking to is really a previous landlord of these lovely people?
Well, one way to do it is ask for proof of payments for the last 6 months. So you're going to see where the payments went to.
Yeah.
And
I just heard that yesterday for the first time.
yeah, I think it makes sense because if a tenant is being evicted, he hadn't paid the rent. So I think that's pretty good, especially when you see when the payments were made. Did they come in on the 15th of the month when rent was payable on the 1st? Or do you see, payments on the 1st and the 2nd? So, basically it's a good tenant. So, but it is difficult to check sources, especially it's one thing to check like an employer that you can independently check that. But unless you're going to run a property check to see that address relates to that name, you really aren't going to know.
And the second part of the question is, I have a property in LA, and now that marijuana is legal, the neighbors are smoking marijuana and it's going into my unit. And, at least once a week, if not twice a week, I'm getting calls from the tenants. I paid for air purifiers. Is there anything
Well, you are allowed, unfortunately, to smoke marijuana in this state, but the reality is you're not allowed to create a nuisance. So I would contact the owner of the next building and say, hey, your tenants are creating a nuisance, okay, and we're planning on filing suit. You might want to also call the city attorney's office and see if you can make a complaint out because they're not allowed to, smoke, regardless if it's from marijuana or from a cigarette. It's a carcinogen, and they're not allowed to create a nuisance. So I would first contact the other owner and see what they can do about terms of curbing where that tenant smokes so that it's not interfering with the residents of your building. Anyway, thank you very much. Moving on to rapid fire here today. Kevin P., how are you?
Hello, Dennis. Can you hear me?
I can.
Hi, Dennis. Question. LA City RSO, fourplex, Section 8 tenant. Section 8 is paying consistently every month. However, she does not pay her $118 monthly payments for the past few months. Still below the threshold. Should I send her any type of 3-day notice monthly or wait until it hits the threshold? What should I do?
I think you started out by saying that she pays her rent, and then all of a sudden we dropped in that she hasn't paid her rent.
Well, yeah, Section 8 is paying, but
Oh, I see what you're saying. Of course, Section 8 is going to pay. So unfortunately, and the city of Los Angeles knew what they were doing when they created this fair market value test, and that in terms of for Section 8, you wouldn't be able to evict them because you'll never get to the threshold. How many bedrooms, for example?
2 bedrooms.
So you'd have to get to $2,625. And what's her share of the rent?
118.
So you're never going to get there even within the first year. However, take a look at your rental agreement. The other way we've been doing this is that it states that you're entitled to a late charge if rental payments are not made timely. So in that situation, what we've been doing is serving a 3-day notice to perform or quit to pay just the late charge, which is not rent. And we've been successful bringing forth those types of evictions.
So when should I do a 3-day after we hit the threshold to do?
No, we can do a 3-day for one late payment of $50. Let's pretend your rental agreement says $50, assuming it's a proper late charge provision. Then we have the right to serve a 3-day notice, not for rent, a 3-day notice to perform or quit for late charges, and that's the way we've been getting around it.
For the late charge. Okay, sounds good.
And thank you, sir. Moving on to Robert Green. Ask you to unmute yourself.
Hi, Dennis.
Hello, sir.
How are you?
I'm good.
Thank you for taking my, I've talked to you before, but I'm a mom and pop, own one home. I have no other, obviously nothing else is on that lot, but this particular 2-bedroom, 1-bath. I have a tenant that's been in there very recently. I actually was trying to exercise a just cause. But the housing department now is saying that the tenant is mentioning that she has a sick mom that visits her on the weekends that's terminally ill. So
let me stop you here. Has the tenant been there less than 6 months?
Less than 6 months.
Are they on a month-to-month or a lease?
They're on a lease, a year lease.
Okay, so well, you can't ask a tenant to move if they're on a year lease unless they're doing something wrong. What are they doing wrong?
Not paying, but I wanted to do the just cause and move in there. But anyhow,
okay, well, you can't do a just cause. I want to move back in because they're on a lease. They're there for the whole lease. But if they're not paying you the rent, then you have every right to evict them. How much is the rent per month?
$3,300.
Okay, my friend, forget the sick mother who's terminally ill, who's coming in every week. That has nothing to do with you. What has to do with you is you're a landlord and you want your rent. So you should give us a call because we would serve immediately a 3-day notice for the rent and proceed forward with an eviction. And the fact that there's some ill relative is irrelevant to this situation.
Okay, because the housing department is basically saying I took a copy of my lease to them over the weekend. So anyhow, I need to shut down this just cause because it's not going to go through, right? Obviously, that's what
It's not going to go through because you have you have
yearly-
just cause. You have the best just cause. They're not paying you the rent. So forget trying to move back in. You can't do that anyway. They're on a year's lease, but you have the best ground in the planet to evict this tenant. They're not paying you. Anyway, thank you very much. And we're going to go to Huba. I'm going to ask you to unmute yourself.
Hi, three questions, Mr. Dennis. First one, we're talking about a house in Westminster. The house is rented by room. The owner is not living there. And first question is, there's no rental agreement. And is the owner has the right to have a copy of the keys of each room that is being
A
rented?
copy of what of each room?
The keys. He has another,
Yes,
copy
of
of the
course.
keys.
The landlord is entitled to a key. I'm sure so each room has its own lock, correct?
Yes.
And when the premises were leased room by room, the landlord had a copy of the key, correct?
Yes.
Okay, but there is no rental agreement.
There's no written rental
So
agreement.
you can't evict on the basis that they altered the premise because you got nothing there. But you can just inform the tenants that I'm going to be changing the locks and I'll give you a key because you're not allowed to have changed the locks. So just go in there with your own locksmith, change them, and then you'll be able to have a key and the tenant will have a key.
Okay. Second question, tenant didn't pay rent and we went to court, and then she was evicted, and there was an agreement of when she's gonna leave based on an agreement, and she left on that date without sheriff or anything. How long do we have? Because I have a judgment against her. How long do I have to be able to try to collect anything from her?
Judgments are valid for 10 years, and then after the 10 years, they can be renewed for an additional 5 years.
Okay. Thank you, sir. Appreciate it.
Yes. And by the way, we do collections. So if you do have a judgment, go to our website, evict123.com. As long as it's not over 10 years old, and up on the top, it says start a collection case, and we're happy to do collections for you. We don't charge any upfront money. It's just on a contingency fee basis. Moving along to Juan Calderon. How are you?
I'm doing good. Can you hear me, Dennis?
Perfectly, sir.
All right. I had two questions. I have an ADU on the in Whittier. Of course, it's not under rent control or anything, but I know California is. But I had a question. I created an LLC, and they pay me through the LLC. But I was reading through my contract. I didn't know about this because I put my name / the LLC name. So they pay me payments under the LLC name. But let's say if I have to evict somebody or somebody falls and they try to sue me, how would that come back and bite me? Because my name is on that. I put Juan / LLC. Is that going to?
Yeah, that would definitely come back to bite you. I would do a change of terms of tenancy that states that Juan Calderon has no ownership interest or management with the property, that it's solely under the name of the LLC.
So I just write them an addendum.
Well, if they addendum, they have to sign. So if they're willing to sign it, that's great. But if they don't want to sign it, then just do a change of terms of tenancy.
Okay, thank you.
Good questions. Moving on to our last caller of the day, Arlene. How are you?
Hi, Dennis. Happy holidays.
Thank you, darling.
I had a quick question. I'm trying to help a friend who is renting a room in a Beverly Hills home. He has a lease. The owner recently passed away, and so the son is trying to evict him. And I can't see any just cause. He's paying the rent, and they are.
Yeah, if he's on a lease, a fixed term lease, he gets to stay there until the lease is over at the very minimum.
Well, the lease is over. The lease is over. He's on month to month now.
So he's on month to month?
Yeah.
And this is a single family home?
Yes, but I don't know if there's JCO in Beverly Hills or not.
I don't think there is, but in any event, he was just merely a lodger. So on that basis, they could just serve him with a 30-day notice to vacate.
Even though he has a lease?
He has a lease, but you're telling me the lease is now month to month.
Correct. So even though it started out as a lease, it's not.
Yeah,
It's
it doesn't
totally
make any
not.
difference.
I see.
Anyway, thank you very much. I want to thank everybody for, actually, I got a couple more calls here. Somebody else is raising their hand. Let's move over to Richard Scott. Going to ask you to unmute yourself. Richard Scott.
I'm on, right?
Yes,
Okay.
you're my attorney friend. And I
That's
forget
right.
where you live. Where do you live, sir?
I live in Wyoming.
Wyoming.
And I just recently sold my last City of Los Angeles building and bought another property in Wyoming.
Well, that's great. Everybody, we should give a big cheer to Richard because he became
the
very smart. He
reciprocal
got
laws
out of Dodge.
They're slightly different in Wyoming. You don't have to post any of these stupid notices anywhere. You cannot, it's impossible to register your unit with any governmental agency because they don't do that, you know. But I have a property building in Culver City. And I set up a Wyoming LLC and registered it with the state of California. But my question is, what do I have to specifically put into the notice of change of management? Because it's just going to be a management thing. Do I have to put in the actual owner or just the entity that is going to be dealing with it?
Well, you're going to have to give the name of somebody who is authorized to accept legal process if they want to sue. You want to head over to my website, which is, of course, evict123.com. In the free form section, drop down to the bottom on the left side, you'll see that form. I even have a tutorial video there. So just use that form. It'll put you on the right side.
Yeah, that, but also notice of how to pay rent. I have to have a bank within 5 miles.
Yeah, you can put an address where to pay. You put the bank's address, put their hours, and put your account number, and that's a lawful method of telling tenants where to pay their rent to.
Do I have to put in the ABA routing number?
No, it's just the account number and the address of the bank.
So if they do want to pay with illegal pennies, they can go down there and do it.
Yes, they can.
But preferred is by electronically, which they can do unless there's been a notice of termination.
Yeah. Now, let me ask you a question, Richard. Have you had any buffalo steaks since you've been living in Wyoming?
They're good.
Yeah. Yes, I know.
We get a little bit of wind, like 144 miles per hour earlier this week.
Whoa. You feel like Dorothy, right? Of The Wizard of Oz.
Yeah. Yesterday, a 150-car freight train was blown over.
Wow.
So,
well, you got to take some good with the bad. Anyway, I'm going to move on to Carranza. How are you? Carranza, I'll ask you to unmute yourself. Okay, we're going to move on to Albert. I was trying to get out of here to my kids' party today. They're having a holiday party. But Albert, how are you?
I'm sorry. I just want to know if you have the seminar next week. Just being between the holidays. Just wondering. Next Saturday, are we on?
Oh, I'm going to be on every Saturday, my friend. Thank you so much. We'll take the last caller, which is DC. Last caller.
Unmute. Hello, Dennis. Can you hear me okay?
I can. Are you all wet there?
Yeah, it's been the water's a little chilly, especially with sharks. That's going to be dangerous. And I wanted to, okay, if I'm going to do an eviction, if I have a tenant that is late on their rent and also they have stuff in their driveway, they store some tools and junk in the driveway. I should do both. If I do an eviction, I should do both.
Yeah, what city is your property located in?
It's RSO, LA units.
Yeah, I would serve 2 notices, one for the storage of the information, storage of the personal property in the common areas, and one for the rent. This way you'll have basically 2 bullets in your gun. So if you miss with one, you still get them with the other.
Oh, okay. And now it has a driveway there. I put all the notices on the driveway and one of the walls, which is actually a wall that is to the front house. And should I put all those notices in the back house too, or the one in
Okay.
the driveway should take
Well,
care of it?
It has to be posted in a conspicuous spot on the property. So if that's a conspicuous spot, then you're good to go. Anyway, thank you very much. I want to thank everybody for coming out this Saturday, the week before Christmas. I do appreciate all the participation and the well wishes. And I want everyone to have a great weekend. And we know without question that the Lakers will beat the Clippers tonight. Have a great day, everybody.